Being sued and taken to court can be a very scary process. I made this video to hopefully remove some of that fear, to explain the process and empower you to assist yourself, and to provide some resources if you need additional assistance. Over the last 25 years that I've been helping Oregonians facing debt problems, I have seen far too many people simply ignore a lawsuit instead of dealing with it. Please don't ignore the suit. A little housekeeping and we'll get right to it. I practice law only here in Oregon and am admitted in the state and federal courts here, as well as the Ninth Circuit Court of Appeals, and to appear before the United States Supreme Court. I've helped around 10,000 Oregonians facing debt problems. Sometimes that involves defense of a lawsuit. Sometimes it involves debt settlement or negotiation. And sometimes it involves a bankruptcy filing. I am proud to be considered a debt relief agency, but this video is not designed to provide specific advice to your unique legal situation or to create an attorney-client relationship. Let's get to it. Okay, welcome back. My name is Michael O'Brien. We're going to talk right now about stopping the suit. Okay, so you've been sued. The question is now, what do you do? And one of the key takeaways here is even if you cannot pay right now, please do not ignore the suit. Through this presentation, our goal is to kind of take that stress meter and maybe turn it down a little bit. We're going to talk about a few things, and here's the outline. First off, how do we know that you have been sued? We're going to go over 3 things not to do, 3 things I want you to do. We'll talk about the statute of limitations a bit. We're going to go over what is an answer. We'll talk about the timeline of a lawsuit, and then we'll go over some additional resources for further help. All right, how do we know you've been sued? Well, here's a complaint. A complaint is a document filed with the court. In this case, it was filed, we can see, in the Circuit Court for the state of Oregon for Multnomah County. Now, the case number right here is empty, but this information that we see up at the top is actually imprinted by the court when a complaint has been filed. In this case, filed September 29th, 2020, 3:14 p.m., the case number and the bit we redacted underneath it. This is an actual sample of a lawsuit filed by Midland Credit Management against an individual for a Capital One credit card. The balance owed roughly $6,000. Tells you it's a complaint, subject to mandatory arbitration, and we'll go over that in a minute. This is an OGIN register. OGIN is the Oregon Judicial Information Network. It is an online database of lawsuits that have been filed in the state of Oregon. Attorneys file cases electronically now, and this manages those electronic forms. We pay to have access to this database. You can certainly have your own access if you're willing to sign up and pay for it. So this is the register of the lawsuit that I just showed you. Midland Credit Management is a contract dispute. There's the filing date. There's the plaintiff. This identifies service. In order for a complaint to be timely filed against you, it has to be served. That schedules the deadline within which you have to respond to the lawsuit. You have to know you've been sued. In this case, it was served October 11th of 2020, so a couple weeks after the lawsuit was actually filed. And the way we know that is because there's a proof of service entry on the OGIN register. So let's look at that next. Here's a proof of service in the same case. This one has the case number underneath there, and it provides the date, the time, an address, the name of the individual who was being served, and it describes the person. In this case, the individual accepted service with direct delivery and confirmed by saying yes, that she was who they thought she was, and it describes the individual. This document is filed by the plaintiff in the court, and it's done under penalty of perjury. I have met with many people over the years who have said, I was never served. How did they get a lawsuit against me? I was never served. Okay, let's look into that. Sometimes those people are correct, and this document will identify someone other than the individual defendant who was served. However, service in Oregon can be proper even if it was not physically and personally served upon you. For example, if the paperwork is served upon your spouse and you live together, then that service can be effective once the plaintiff mails a complete copy of the complaint to you. So that becomes a two-step process: physical service of a document on someone other than you, and mailing of the document to you at that address. Service can also be proper if it was left with someone over the age of 14 who resides at that residence. Maybe it's not a spouse. Maybe you have a roommate. Maybe you have a teenage son or daughter over the age of 14. Service can still be proper upon them. So just because it was not personally served upon you does not mean that it was not valid service, and therefore you may still be at risk in this lawsuit. Okay, so what do you do now? Well, there's three things we don't want you to do. We do not want you to ignore the lawsuit. I don't want you to delay acting. And I don't want you to assume things. And we'll go into that in detail. I do want you to educate yourself. I do want you to act quickly. And most importantly, I do want you to take control over this process. All right, don't ignore the suit. Here's the thing. When a lawsuit's been filed against you, you have to do something. If you don't do anything, you're going to lose. You may disagree with the lawsuit. It's complete rubbish. You don't owe any money whatsoever. You have to raise those as defenses in your response to the lawsuit. If you ignore it, you will lose. And if you lose, then the plaintiff is going to earn a money judgment against you. Now, a money judgment is simply a piece of paper signed by a judge that says you owe money. Armed with that money judgment, the plaintiff can use it to garnish your wages. They can use it to garnish your bank accounts. That money judgment can become a lien on property, real property that you own, land or buildings. And that judgment is good for 10 years and can be renewed for 10 more. So ignoring the lawsuit, allowing the plaintiff to get a judgment against you, creates this 20-year cloud. So please don't do that. Don't ignore the lawsuit. What you should do is don't delay either. I mean, you have a certain amount of time to respond to this thing. If the lawsuit was in circuit court, as the example that I showed earlier, then you get 30 days to respond to it. If it was in small claims court, which would be in the caption of that lawsuit, you only get 14 days to respond to it. Now, days for these purposes count from the day of service. So in my example, the lawsuit was filed on September 29th, but not served until October 11th. The time to respond starts from that October 11th, that date of service. If it was served upon someone else in the household and then mailed to you, then that timing can change. So it's important to look into that. If the last day for you to respond falls on a weekend or a holiday, then the law carries that forward to the next business day when the court is open. All right. The idea being you don't have to file in less than 30 days. You get the full 30 days plus a couple sometimes. And by the way, lawyers and sometimes you can get an extra 10 days. So if you were out of town, if you realize it, you just couldn't get to it because life was happening, and day 30 is upon you, don't give up. Maybe call up a lawyer seeking help, or call up the lawyer who represented the plaintiff filing the lawsuit against you and ask them for some additional time. Maybe you need to meet with an attorney, and you can tell that opposing counsel and say, I want to meet with a lawyer. It's going to take me another week to get in and meet with somebody. Can I have some additional time to file an answer to the lawsuit? Most lawyers are going to say yes to that request. I always think it's a great idea to invite them to maybe send you an email confirming that, just so that you have something in writing. Most important thing here, don't delay. You need to act. But I also don't want you to assume things. So for example, don't assume you can connect with the opposing counsel or the plaintiff's lawyer. If you wait till day 30 and you call them up, you may not get a hold of them. They may not be in the office that day. They may have a whole lot of cases they're working on and can't get to yours. It is not their responsibility to give you a call back. It is your responsibility to respond to the lawsuit. Don't assume that the plaintiff's attorney is going to give you legal advice. They are not. They don't represent you. They represent their client, and they are not going to give you any advice about how to defeat their client's claim. Don't assume that the plaintiff's attorney cares at all about the why behind the lawsuit. You got sued because you couldn't pay a medical bill and you lost your job, and you were off work for a while, or you had disability. I mean, those are horrible things that happen to real life, honest Oregonians. But the plaintiff doesn't care. The plaintiff's job is to advance their lawsuit, to win, to get that money judgment against you, and then to collect. And they don't care about the why. But I also don't want you to assume that the plaintiff is going to win anyway. The plaintiff may not win. You might have defenses to the lawsuit. Maybe you paid the bill. Maybe the medical provider didn't submit the paperwork to insurance the right way, and your insurance should have paid it. There's lots of reasons why you may not owe whatever money it is that you're being sued for. So do not assume that the plaintiff is going to win anyway. Also, don't assume that you have no control. Control of the process is important. The timing here is important. And even by filing a simple response to the lawsuit, you have taken a little bit of control back. I use the punching bag analogy with my clients. Don't be the punching bag. Don't just hang there and let them throw punches at you. Do something. Call them up, call a lawyer, file an answer, do something to take back a little bit of control. And so what should you do? Well, the first thing you should do is educate yourself, and you're doing a good job of that right now. Learn a little bit about the process. What does it mean? Review your records. Do you owe the money? Maybe you don't owe the money. Look into it for yourself. Get some help if you need it. At the end of the presentation, I'll give you some information on some additional resources that you can seek to get some help. Do act quickly. I talked about the timelines within which you must respond to a lawsuit. Those deadlines have real-world consequences. Now, it is possible to undo default judgments. If a judgment gets entered against you by the court, you didn't have or didn't feel like you had enough time to respond to it, that default can be undone. But it is much harder, it is much more costly to undo a default than it generally would have been to respond to the lawsuit in the first place. Okay? And the judge doesn't have to grant your request to undo the default. If the judge looks at the documentation and says, well, I'm sorry, Mrs. Smith, but you would have lost anyway, then you lose. And the judge does not have to undo that default. And I can tell you from experience, the plaintiff will march into court on day 31 if you don't respond on time. Now, march into court in a pandemic may mean submit paperwork electronically to the court, but it will happen on day 31. I see it all the time. Do take control. Do something. File an answer. Protect yourself, protect your family from that judgment, from the garnishing of wages and bank accounts and liens on property. Think of the future, not necessarily the now, and think big picture here. And let me tell you what I mean by that. So when I say think of the future, what I'm talking about is you may not have the ability to pay the debt back right now, but maybe in the future you will be. Maybe when you file a tax return, you're going to get a tax refund. And so maybe then you'll have the money to pay that creditor back. Well, if you ignore the lawsuit and they get a judgment, they're just going to take things. Whereas if you file a response to the lawsuit and you seek to control a little bit, maybe you can negotiate a payment plan for that debt. So think about the future, even if you can't pay it now. But also think about the big picture. And by that, I mean, sometimes when people get sued, it's the tip of an iceberg. It's the first of other suits that may happen. Sometimes, not always, it's indicative of a bigger problem. And so I've seen people who, fix the squeaky wheel, right? They get sued, so they take their money and they pay that creditor, when maybe there's a bigger issue that needs to be addressed. If you're behind on a mortgage payment, if you're struggling to make a car payment, if your utilities are falling behind, or God forbid, the food bill is not getting paid, then this creditor is probably not that important. You still need to do something, but you might kind of escalate the response a little bit. I hate it when I talk to people and they fell behind on their mortgage payment because they were paying Visa. Man, let's work out some deal with Visa, but keep your mortgage payment made so you don't lose your house. So think bigger picture. We're going to take a little break from the PowerPoint presentation for a minute to talk about statute of limitations. Now, many people have heard the phrase statute of limitations and generally understand what it means, which is basically a deadline before which any claim must be brought. Now, what most people don't know is that there is not a single statute of limitations. As a matter of fact, here is the book on Oregon's statutes of limitation, which is, 600 pages of material. There's maybe 100 statutes of limitation in Oregon alone, pertaining to all types of different claims that may be brought against you. Most lawyers don't understand I don't understand all this stuff. Are you kidding me? It's crazy. But let's make it simple. For most lawsuits involve a contract or an agreement to pay money, whether that's a credit card debt, whether that's you agreed to pay for medical services that were provided to you. Those are contract disputes. And in Oregon, the statute of limitations for a contract dispute is 6 years. 6 years from when you agreed to pay it, or last paid it, or last acknowledged you owed it. So the devil is in the details here. And even though something may be 10 years old, if you made a payment 5.5 years ago and get sued this month, guess what? It's not outside the statute of limitations, and therefore the claim can be valid and brought against you. Now, here's another thing that trips people up a lot. The statute of limitations does not prohibit a lawsuit from being filed. It is what the law calls an affirmative defense, meaning in order to raise the defense of a statute of limitations, you have to actually bring it up. You have to, in your answer, say, wait a minute, this is barred by the statute of limitations. And then the court can consider it. I have seen so many people for whom a debt is really too old, but because they ignored the lawsuit and did not raise the statute of limitations, they ended up losing and having a judgment entered against them. Please don't let that happen. Okay, let's get back to it. Okay, when we talk about an answer, what does that mean? Well, it is a formal document filed with the court. Here's an answer that we've prepared or used just for this presentation. Your answer doesn't have to be this formal. You don't need all these numbered lines down the side. If you represent yourself, which you're entirely entitled to do in Oregon, the court is going to give some broad leeway with an answer. It needs to have certain things so the court knows what it is. So this part up here where it identifies the state and the county and the name of the plaintiff and defendant, it includes the case number. It identifies itself as an answer, okay? That is the caption, and you need to have that. You then need to respond to things. So in the plaintiff's complaint, they made certain allegations at paragraph 1 or paragraph 2, and you admit or deny that information, or maybe you lack information to admit or deny what was going on. But you need to address each of the paragraph allegations that were in the complaint. And you need to tell the court what you want. You want a judgment that says the plaintiff gets nothing. Dismiss their complaint. Give plaintiff nothing. Don't allow them to have any money. Put your prayer in there. You have to sign it. You have to date it. Now, lawyers file documents electronically in Oregon. Individual non-lawyers can certainly paper file. I understand that may be difficult. We're in the middle of a pandemic right now. But there will be a process at the court to allow you to paper file an answer to a lawsuit so that they don't take judgment against you. Answers can include counterclaims, which would be, I don't owe plaintiff, plaintiff owes me. That is a counterclaim. Answers can include affirmative defenses, like the statute of limitations that we just talked about. Answers can include third-party claims. I don't owe plaintiff, but my neighbor Bob owes me to pay plaintiff. All of those things are well beyond the scope of this presentation, but the point is that whatever you think should have happened can be put into an answer and submitted to the court. Once you do file with the court, you do have to serve that upon the plaintiff. So put it in an envelope, drive over there, hand deliver it to them. You can ask the sheriff to serve it upon them. But it does have to go back to the plaintiff, the plaintiff's attorney, so they know that you've actually appeared in the lawsuit and filed your answer. Okay. Now, why answer? Well, like I said before, because it gives you a little bit of control back over the process. And even if you cannot pay now, maybe you can negotiate with the creditor a discount. In the example I provided, that individual is getting sued for about $6,000. Well, that creditor might accept $4,000 right now to make the whole thing go away. Okay, just save yourself $2,000. Now, you got to have the $4,000 in a lump sum to do that, but that may be an option. Maybe that creditor will accept payment over time. You can't afford $4,000, but you can afford $6,000 just at the rate of $100 a month. Okay, plaintiff may agree to that. There's a way to establish a payment plan that actually keeps the plaintiff out of your bank accounts, out of your wages, and keeps liens off of real property. Options do exist with that. But of course, if you do nothing and they win, well, throw those options out the window. All right, so let's talk about the basic timeline of a lawsuit. Again, don't ignore it. So day one for our purposes is when the complaint is served upon you, when that service is effective, because that is when the clock starts ticking. And your answer is due 30 days later. Now, as I said, if it's a small claims lawsuit, then it's only due, you only get 14 days to respond to it. And if the 30th day falls on a holiday or a weekend, you carry that forward to the next day. In the example I provided, and in many cases where the dispute is less than $50,000, the court is going to require arbitration. It is a non-binding arbitration. And so once an answer has been filed to the lawsuit, the court will appoint an arbitrator to hear that lawsuit. Now, the arbitrator is an Oregon attorney who has agreed to put their name on a list with the courts, who has agreed to serve as, judge, if you will, or informal judge. That's what the arbitrator's job is, to help parties reach resolution of a lawsuit in a more cost-effective manner than going to court and going through a trial. So in an arbitration, you would show up, plaintiff would show up, plaintiff would put on their evidence explaining why you owe the money. You would put on your evidence explaining why you don't owe the money. The arbitrator would make a decision. Historically, that has been done in a big conference room. During a pandemic, that can be a Zoom conference. And so people could still appear and present information about that. The arbitrator will make a ruling, and the arbitrator will submit that ruling to the court. You have the ability to reject that arbitrator's ruling if you lose, and to demand that a judge actually hear your case. That can be very expensive. We generally advise people to address the problem much earlier in the process. If you end up going to trial before a judge, you're spending a lot of money. A decision is made generally between about day 90 and day 180. So if the case is assigned to arbitration about day 45, there's about 45 days to complete the arbitration. So a decision may happen somewhere between day 90 and 180. And of course, that widely varies depending upon the county, depending upon judge availability for trials. But generally speaking, we look to day 90 and 180. Now, keep in mind, again, think about the future, not the now. If you go through this process, then you may delay entry of a judgment against you for 90 to 180 days. Maybe something will happen during that time frame when you can solve the problem, whether it's getting back to work, whether it's getting a tax refund, maybe a bonus from work might help solve the problem. So controlling the timeline may give you additional opportunities. But the timeline can last a long time here, so 10 to 20 years. As I mentioned, once a money judgment is entered against you, it is good for 10 years and can be renewed for 10 more years. So it is a 20-year cloud within which you could be collected for that debt. If you need some additional assistance, there are resources available. The Oregon State Bar maintains what they call the Lawyer Referral Service. There's a phone number right here. These are Oregon lawyers who have agreed to meet with people on a limited basis. They'll provide a 30-minute consultation and they'll charge you $35. So for that fee, you can go in, meet with a lawyer, get some basic information. Not all Oregon lawyers have agreed to participate with the Lawyer Referral Service. The Oregon State Bar also maintains what they call the Modest Means Program. The number to get a hold of them is the same. The Modest Means Program, again, is for lawyers who've agreed to participate in that program. And if your household income and assets are below a certain threshold, then they will agree to represent you in certain cases at reduced hourly rates. Those hourly rates generally are between $60 to $100 an hour. But the Modest Means Program only exists for certain types of cases: family law cases, criminal defense, foreclosure, landlord-tenant cases. And so the vast majority of contract or money lawsuits out there, collection, credit cards, medical bills, the vast majority of those lawsuits would not qualify for the Modest Means Program. And in order to be accepted for the Modest Means Program, you have to submit paperwork to the Oregon State Bar. You have to answer a bunch of questions, give them a bunch of information about your income and your assets so that they know whether you qualify or not. and then they will assign it out to an attorney. It is not automatic. Another place to consider looking at are county legal aid programs. Now, LASO, Legal Aid Services of Oregon, is the one that comes to mind. But each county has most counties have a different legal aid system program in place. These are generally pro bono or for free lawyers who are willing to assist people. But as you can imagine, there are limited resources out there. There's a limited number of legal aid programs. Those lawyers generally who work for the legal aid societies are paid. And so the legal aid society gets their money from donations, state, county, the Oregon State Bar, donations to fund them. And so you may not get a lawyer who would be willing to take that case. They may not have the time and energy, and to a lot of extent, they have to prioritize. So if they're facing a heavy caseload of family law matters, of child support, child custody, maybe it's child security issues. Obviously, those lawyers are going to be devoting their times to those issues more so than the collection type lawsuits, but certainly worth looking into. You can also contact us or other lawyers who do this type of work. For my law firm, we maintain 3 offices. Our Portland office is in Southwest Portland, right on the border of Tigard. We have a Clackamas office over on Sunnyside Road. We also maintain an office in Bend. For many years, I had clients come to me from Bend. Finally, about 3 years ago, we decided to open a satellite office there so that people didn't have to travel as far, and we would go meet with them at our Bend office. And so, there's me and a little bit more about me. But basically, to summarize here, the most important things are, please don't ignore the lawsuit. Please act quickly, educate yourself, take some control back, because even by filing an answer, you have gained a little bit of control to try and negotiate something with the other side and to, hopefully get it resolved in a way favorable to you. All right. Thanks for watching. I wish you the best of luck. Take care.